Hey, J-Bone Nation! Shaming of Jay. He's not a dopey dumb bitch. He gets laid. The court jester. The court DJ. It's time to dive into the case. To the case.
What's up, everybody? We are here for a little pre-trial primer on the Ashley Benefield, Florida versus Ashley Benefield case that is starting next week. Monday is jury selection. Tuesday, the trial will start, and that's the next trial we are covering. We figured a good way to kind of catch up on this case is there was a pretty important hearing, a stand your ground hearing. It was 2 days, but really it was 1 day because the second day was like an hour. As you can see here, the description says 2 days of motions hearing surrounding a stand your ground offense. The former ballet dancer accused of murdering her husband, Douglas Benefield. Detectives say Ashley went to a neighbor's house in September 2020, claiming Douglas attacked her, so she shot him. However, during the investigation, it was discovered Douglas most likely had his back to Ashley when he was shot. The couple reportedly got married 13 days after they met. So this is that hearing, and there's a lot of witnesses, regarding what happened. So I think we're just going to go through this. Started off with this opening. This is the defense attorney, I believe, giving his opening kind of statement in this. So is this especially like? This is basically like a kind of like a small trial where they're trying to determine if not a trial is not the right word, but
No, but it is. It's a mini trial because a lot of hearings are just legal argument. So it is like a mini trial to determine whether or not she could even assert the stand your ground defense, which ultimately they decide that she cannot. But you do get to hear, a lot of what they're thinking and how they're framing it. And I think where she falls now, I don't know any of the drama behind this. I don't know anything about the case other than what I've learned in the past, hour and a half. But I think is more like a battered woman syndrome defense. So the because that doesn't rely on whether she's like an imminent fear right then and there, because you can become in fear under a battered women syndrome, over time, and maybe be more fearful in the present moment because of the prior abuse, psychological, and or physical, uh, at the time of the actual shooting. I do know that they were in a very heated custody battle. She did accuse him of poisoning her and their child, which the family court said they did not believe there was evidence of that, and that this shooting happened just before another big section of their custody battle was going on, but that I think that there was something. What I heard, the last thing I heard before I couldn't, uh, continue listening, was something to the effect of they were trying to get back together, and it sounded like the defense is arguing that was a ploy sort of to make him feel at ease and then kill him. But I guess we'll hear some of that now.
Yeah, so we'll start with the argument, and then I think what we're going to do is we'll go to the witness, see what they're going to testify to. If we think it's important, we need to know it, we'll check it out. If not, we'll skip, and let's start. Now, this for some reason, this hearing doesn't start, like, this guy's already arguing, so that it's not that, I guess they started late with their feed, but let's see what this is the defense attorney. Let's see what he has to say.
Was reasonable. So to that end, as the court is aware, we established a prima facie case that the force used was justified. The state stipulated to that, and Your Honor signed an order so designating it. At that point, the burden shifts to the state to establish that the force used was not justified. That's what the statute says, and that's what the case law holds. The standard that state has to meet to do that is clear and convincing evidence. So that leads us to what I think is a very appropriate consideration, Judge White, which is what are the parameters of a motion such as a stand your ground motion? I would suggest to the court that was pretty well defined in the second DCA case of Bowie versus State. I'll give the court the site at 290.
Like, for example, I don't need, we already know this was rule. Like, I don't need him to explain what a stand your ground hearing is. So let's,
to Southern
unless you think we
Third.
should watch it. What do you think?
I mean, to me, it's interesting, but that's because to me, what's more interesting is the legal argument. But I'm sure to everyone else, more interesting is what the people are going to say. But it's going to give you a framework of what he's about to get into and who you might hear from. Maybe
all right,
1.2.
Yeah, okay. I'll do that.
471 and specifically page 483, second DCA case 2020. The court there pretty much stated that the inquiry for the court is to entertain any evidence which establishes that the force that was used was not justified, which means, Judge White, that any other inquiries are irrelevant, specifically motive. Motive, a lot of times at a trial, is not required. It's never an essential element, but when it is available, it's a very powerful tool for the state to present to a jury. Abuse allegations, also irrelevant, as is Ms. Benefield's psychological state. Why are they irrelevant? They're still, of course, subject to the rules of evidence, even if the court entertained them. But the question then is, why would they be irrelevant? And it's our position, Judge White, that they're irrelevant simply because they are not material to the stand your ground statute's requirements. As the court knows, the issue is, was Ms. Benefield in a place where she had a right to be? Was she involved in any criminal wrongdoing? And did she have an objectively reasonable fear of great bodily harm or death? So the case law supports exactly that. One of the benefits, Your Honor, of being in the Second Circuit is we have very well-defined case law on stand your ground. And I'll cite to the court two things in particular that should apply across the board to this hearing, respectfully. The first is in Riggins versus State, which is in our brief. It's at 344 Southern 3rd, 625, page 626. Also a second DCA case in 2022. Therein, the court held that the trial court, this is a quote, the trial court is to assume all facts as true. Secondly, I would cite to the court, also in our motion, the case of Jefferson versus State, 264, Southern 3rd, 1019. Again, a second DCA case, 2018. Here's what the Jefferson court had to say in upholding the stand your ground motion and immunity filed by the defense. Quote, we are mindful that there will be situations where the accused is the only available witness to the events leading to an act that is claimed to be justifiable use of force. This may result in great difficulty for the state to overcome the accused's prima facie claim by clear and convincing evidence. But our result here is mandated by the text of section 776.032, subsection 4, stand your ground. In closing, Judge White, I think that the state will be unable to demonstrate in any capacity, much less by clear and convincing evidence, that Ms. Benefield, knowing what she knew on the day of this incident about DB, which is the objective standard, Douglas Benefield, was not justified in using deadly force to prevent great bodily harm to herself or death. Thank you.
Thank you, sir. All right, State.
State calls Tommy Benefield.
Oh, starting
we-
with the relative.
So did we miss the
Now.
states? I guess they didn't air the states opening
Yeah, we must have missed that because it started a little bit
'Cause-
late.
because he started what I started to hear was they stipulated to certain things, which I guess at the end of the day isn't going to matter. Maybe they just stipulated that she was at her house, and that she had she was, can invoke the. It seemed to say he said that they stipulated it was justified, which I don't understand. But yeah, So who's the first witness?
Benefield. It sounds like I think maybe his brother or someone related to the.
Alright.
Let's see.
We're into our, I'm in this motion and then
Trial starting Tuesday. Monday is jury selection. Melmac.
Oh, so we can do another thing on
Whatever it
Monday.
is on the
then.
record, we're going to get
Yeah, we could. Yep.
to
Yes.
Tommy Benefield.
number 2, yeah.
Number 2.
I had lodged an objection to any Benefield family member testifying without personal knowledge of or participation in the events immediately preceding the alleged homicide. I then followed that up with a discussion about
Julie Pugh says
testimony
it's a
by
first
non-expert
cousin.
witnesses who lack personal knowledge and cited the Florida Evidence Code. And I also included in the memorandum for Your Honor the following. As the court knows, in a homicide case, the accused has the
So right now
absolute
he's just
right
arguing-
to open the door or keep it closed as it
Whether this
relates
guy
to
can testify, we know he's going
Right.
to testify, so I could probably just fast forward, right?
Yeah.
Or do you want to see it?
character
No, I don't think.
permit yet to
All right, let's see what the judge said. Though.
But that one, and I'll reserve where we're going.
reunification for peacefulness, which the Florida Evidence Code does not allow. That's our objection, Your Honor, respectfully.
Thank you very much. State.
And Judge, the state does not intend to elicit testimony about reputation.
Okay. This is a great example of what I was saying when we were talking about the hearing is I heard your objection. I'm going to reserve on it because I don't know what these witnesses are going to say. I don't know quite where we're going. You guys know the case so much better than I do. So for now, I'm going to allow it and I'll reserve at the end so keep making your objections. I'm going to reserve on those, at least this one.
Understood.
Some of them might be a more clear call, but we'll pour it all in the pot and see what we get.
Understood, Your Honor, and I might say I'm quite comfortable with the court proceeding that way. I have no doubt.
Thank you.
And
But
that's
let me say
because
this.
the judge make your objection. He's about to say, still make it, because a judge can, ignore it, even though he's heard it. In theory, ignore it for the purposes of his legal decision.
If I remember, I like this guy. This
He
judge.
seems
If I-
good. So he seems to have a good personality so far. Obviously, not hearing much, but
Having sat on both tables, you make every single objection as we go that you feel you need to make. But I understand completely. You have just a general objection to all of that character evidence, the background. You want to focus on that particular day. Got it. Yes, ma'am. Okay. Thank you.
Tommy,
Just for the microphone, please.
Hello, sir. Morning, Judge. My name is Judge White. I'm presiding over this hearing. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. You adjust up, down, left, right, wherever you're comfortable. If you're just speaking a loud, clear voice, it'll pick everything up.
Yes, sir.
good morning.
Good morning.
We just ask, can you see?
I can, Your Honor, to lean back a little bit by the court reporter.
If you need to readjust yourself or reposition, please feel free to do so. Yes, ma'am. I'm sorry.
Please state your name.
Tommy Douglas Benefield, Jr.,
How do you spell your names?
TOMMIEDOUGLAS BENEFIELD, Jr.
And what was your relationship to the deceased Doug Benefield?
First cousins.
And how close were you?
We were close our entire lives, and I was instrumental in him going into the Navy when I was in the Navy. Both naval officers, both flying off aircraft carriers, both did other work for the government, and then all the way through his business career and his dual career in the government and in private. Probably talked weekly to monthly, depending upon the times of our lives.
Okay.
I visited his family multiple times in Charleston.
And let me just ask
yes,
you,
ma'am.
before he died, where did he live?
Well, he was in an apartment down here at the very end.
But before he moved to Florida, where did he live?
Charleston, South Carolina, 701 Preservation Place.
And
this is the first cousin.
where do you live now?
I split time between Jacksonville, Florida, and Atlanta, Georgia. My wife and I have a spa business in Atlanta, Georgia, and I work 2 weeks a month in Honolulu, Hawaii.
And what is your job?
I'm a flight instructor for Hawaiian Airlines.
I'm not sure if Jake
Teaching
can hear me.
pilots
So I was going to say you could
in a particular
skip
airplane.
some of this
So let
background.
me ask you a little bit about Doug.
I could
At
skip.
the time that he was murdered,
Well,
how
now-
old was he?
He
They
was
Wait.
just
actually
1
jumped
week
right
short of
into it,
59.
yeah.
He's born
I didn't know if they
October
were going to
5th,
do a lot of background.
1961.
And how tall was Doug?
5'9", 5'10".
How much did he weigh?
I'd say 160 to 170.
And you already said before he moved to Florida, he lived near Charleston, South Carolina.
In Mount Pleasant, a suburb on the north side of the river.
Okay. And just before he moved down here to Florida, who did he live with in the house?
Just Eva and himself, except for the time that Ashley was living there previously.
So you said Eva.
Eva's his
Who's Eva?
teenage
Eva
girl.
is his biological daughter, first daughter, with his longtime wife, Renee.
And how old was Eva at around this time?
15, I believe.
So a teenager.
Yes, ma'am.
When did you first meet Ashley?
I had an overnight. I was flying for Southwest Airlines, had a change in a schedule. They sent me to Charleston, just me, not the rest of the crew, to take a plane into Charleston. And I texted Doug and said, hey, I'm going to be in Charleston tonight. Let's go to dinner. He texted back, great. April 14th,
You might be able to
2017 was the
like
date.
You seem to
blip
remember dates
until
well.
you hear them
I-
actually talking about the relationship. I don't know. I don't know
You
because
want me to
I
put it
don't
at like
know.
1.5 and then we'll see how it goes? It's
I have a very good memory now.
Okay. So you remember the exact date was April 14th?
Yes, ma'am. And I keep a diary and a flight log, so I know exactly when it was.
So did you in fact meet up with Doug?
Yes, when I got into Charleston, ahead of the hotel, I texted Doug again, and he said, Ashley's not feeling well. Could you take Uber up to Mount Pleasant to the house?
Overruled.
Did you know who Ashley was?
I had never heard of Ashley at that time.
So he spoke it like you knew who she was.
Yes, ma'am.
Did you take an Uber to their house?
Yes, ma'am.
Once you got to the house.
Hearsay's
did you
allowed
meet Doug
pretrial hearings.
I met Doug
by
and
the
Ashley
way.
together.
And Ashley. Was that the first time you'd ever met the defendant?
Yes, ma'am.
Did you speak with both of them together about their relationship and how they met? I'm assuming you were basically like, who are you?
We spent 4 hours together.
Okay.
We started at the house. I got her short life story, their life story together at that time.
So their life story together at that time.
13 days before
Did
they
they
got
say how
married.
long they had known each other before they got married?
Yes, ma'am. It was almost a sense of pride for both of them that they had only known each other 13 days.
And how old was Ashley at the time?
At that time, Doug was 54 and she was 24, I believe.
So
Wow.
30-year difference
Yes, ma'am.
between them. And I think you already answered this earlier, but did Eva live in the house with the two of them?
Yes, she did.
Did the defendant ever mention that she had a job?
No, ma'am. It was only past history stuff and what she was doing temporarily in the 2016 timeframe.
Was she interested in the ballet?
Yes, ma'am. She was a former ballet dancer. And by this time, they talked about the American National Ballet they had founded in February.
So let me stop you
Yes,
there.
ma'am.
So was Doug interested in the ballet?
The way a husband is, proud of his wife, supportive, knew nothing about the ballet except its existence, I think, prior to that.
And prior to this meeting with Ashley and all this, had he ever expressed any interest in the ballet?
No, ma'am.
Okay. So you mentioned February. So they started a ballet in February?
So there was an old ballet that was defunct called the American National Ballet. When Ashley wanted to start a ballet and make this a special ballet, a diverse, non-judgmental, non-stereotyping ballet,
13 days after I get my haircut, I don't even know if I like it. 13
Doug found a
days.
name and found an old ballet, and that's, I believe, February 27th of 2017 is when they founded it on paper.
So a couple of months
I'm
before
sorry,
we met.
Suzanne. Continuing relevancy objection. I don't want to keep.
Understood.
So you mentioned that was February of 17. So that was roughly 2 months
Yes, ma'am.
before you met Ashley. And how was the ballet being paid for? Did they discuss that with you?
Doug did. They both did.
Okay.
Uh,
Ashley did as well.
she talked about it.
Yes.
She understood what Doug was having to do to raise money and to put money personally into it. Doug was very, very good in all his businesses about doing the founding paperwork and establishing an LLC. And he had done the same with the ballet.
So
He
Jay,
built a website.
Yo,
for the ballet stuff, I can tell you that they started this ballet and he, like he's saying, he put all the money in it. They got it started. They hired this guy. They were supposed to get like this big space that never happened. People were excited about it. It was supposed to be different, like he said, all inclusive and different people, not like your stereotypical ballet kind of strictness and very specific body type. And when she got pregnant, she stopped doing the ballet, and in fact, then she left and moved in with her mother in um, a different area of Florida, and that's when all their battles kind of started. So I don't know if we can, if you want to fast forward through some of this background.
Okay.
Just typical of Doug to build it all himself.
Did he also have other money? So it was actually formed in February of 17.
Talked about the upcoming
So
events.
he was wealthy.
There was an
it
informal
seems
launch
he
in
was
May.
wealthy. You know,
There was
he
a formal
was in
big donor
tech.
party that I was a part of, brought all my business partners, a lot of veterans that I work with, to a McKee House event in August, I believe 12th of 2017. So that's the ballet that I learned when the event was coming out, and planned on being there and bringing all my people.
During this time, 2017, at some point, did Ashley and Doug decide that they were going to have a child or try to have a child?
That wasn't a part of that first meeting night. We talked about everything else and caught up on everything that we hadn't known. But it wasn't a part of that night. We ended up leaving the house, going back to my hotel, having dinner together. I'm a master trainer in a medical device. It's a pain relief device. It helped her, helped him.
On specifically with the defendant about the child.
Certainly. Vasectomy reversal is a very intrusive surgery for men. And when they made the decision they were going to do that, he and I talked about it at the time.
Oh, he got the snip, snap, snip. He went the back after the
Well, it sounds like
vasectomy.
they wanted to. I don't know if they actually did or not. Maybe he's
In particular, because of my medical device background, that could help him.
So they decided as a couple that they were going to have this vasectomy reversal to try and have a child.
Yes, ma'am.
And did
Michael
the defendant
Scott.
get pregnant that year?
He had the vasectomy reversal, and 3 months later, she got pregnant, I believe.
Wow.
Because we talked about it later, that the conception date was July 10th of 2017.
And at some point, shortly after that, did she move away from their home in South Carolina?
Yeah, so August 12th is when we had the McKee House event, the big donor event, introducing the other members of the staff of the ballet and everyone involved. Ashley and her mother, Alicia, were there. I was there.
oh, he had a reversal.
2 weeks later, I believe on the 26th or 27th,
She
they made the
paid for it.
decision together that it would be better for her because of her morning sickness to go live with her mother because Doug traveled for work and
Oh,
was
there you
busy,
go. That's
and
what you're talking
that
about.
was what was presented to me by both of them.
And her mother lived in
Lakewood Village here in the Sarasota-Bradenton area.
Florida.
Yes, ma'am.
And so shortly after that, did Ashley move?
I believe on the 27th of August, because Doug called me both on the way down and the way back.
Did he help her move?
Oh, yes, ma'am.
Did he move with her?
No, ma'am.
He stayed in South Carolina?
Yes, ma'am.
So that was August of 17.
Yes, ma'am.
Did the ballet eventually go under? And when?
So the ballet opening, the actual launch to the public was September 18th of 2017. That's a landmark date in this case in my history because it's the date Ashley and her mother went back in the house and got her stuff and she filed against him.
We're
Okay,
talking
we're not
about a
talking about
ballet.
So
So
shortly after this whole time,
she wanted to start. She was a ballet dancer. She wanted to start a ballet company. They did start a brand new ballet company. He put a lot of money into it. She got pregnant. She moved in with her mother. This witness is testifying that it was because the mother could help her with her morning sickness. I don't know if that's what the defense's position is or not, but apparently that's what was they together told him. Whether it was the real reason or not, I guess we have yet to see. They had once the child was born, a lot of custody battles. She accused him of poisoning her and the child with some kind of metal. The family court judge said, no, I'm not buying that. Then as the custody battles heated up, someone out there probably knows more than me. I think they said that they got back together. And I think the defense is trying to say that was a sham, but she shot him and claimed self-defense. This is the stand your ground hearing to see if she can assert Florida's stand your ground defense. And this is the first witness, the cousin. Some people.
and we're going to skip ahead. Did the ballet eventually collapse completely?
Yes, ma'am. I'll answer it more directly. I apologize. So they launched it publicly on September 18th. The biggest performing
The
arts
answer is
center in
yes.
Charleston is
Just say
called
yes.
Gaillard Center, big performing arts center. And they actually held an opening performance on December 7th of 2017. And the dancers had been paid through December 15th. And by the end of the month, everything was finished.
Okay. So by the end of December 2017,
Everything's done.
it was defunct.
Yes, ma'am.
During the time that you encountered Doug and Ashley together and talking to Doug, how did he act about Ashley?
He was completely in love, completely supportive, starstruck, visibly, physically. You could tell by the way he treated her, took care of her on the opening night that I met him, met her, and then it continued through the entire relationship until I never saw them together after the separation.
And when was that?
Well, physically, August 27th of 2017, when he drove her down.
So you never saw them together after that you can remember?
Well, I'll leave a caveat on that. I spent a weekend down here with Doug, Ashley, her mother, spent one night in the home where Doug was killed or murdered. And I don't remember that date. It could have been after the separation, probably was, but I just don't remember that date. But that would have been the only time that I saw them together after that August 27th period.
Thank you. I have no other questions. The defense will probably have
Okay.
some questions.
Do you think I even need to watch the cross? Like, what?
Well,
like-
now it's just I don't know. So they just called him just to say all that. I mean, I don't know. Maybe not.
Thank you.
Based on my evidentiary ruling so far, how do I say this? I know you probably wouldn't have asked a bunch of questions, but certainly for your cross-examination, any proffers of cross, I understand it's going to be broader than what it might have been.
Maybe not.
All right, maybe not. And
He's
please,
gonna
sir, feel free
proffer it.
you can question from either podium, wherever you feel more comfortable.
Thank you.
Oh no, he's gonna talk. Question.
Ashley Benefield. I regret. Good morning, Mr. Benefield. I'm Neil Taylor. I'm appearing on behalf of Ashley Benefield. I regret that I meet you under these circumstances.
I understand, Mr. Taylor. Thank you.
You were a pilot,
Yes, sir, still am.
and consistent with being a pilot and listening to you and your detailing of events and dates and times, it's pretty stereotypical of the discipline that a pilot generally brings to their profession. Would you agree?
Yes, sir. You want the best people up front that work like I do.
All right. And you've told us that as a first cousin, you were very close with Doug Benefield.
Yes, sir. I was closer with Doug in our adult lives than my own brother, who was still alive at that time.
All right. Now, Doug was not a pilot,
Yes, sir, he was.
a commercial pilot.
No, sir, a Navy pilot.
Okay. Not a aviator, not like the second seat, but the actual pilot.
So,
Well, who
in-
cares
I mean,
about this shit?
and then he
Yeah.
became a second in command, which in that airplane. So he flew the plane.
Now, being as close as you were to him, you were aware, were you not, that he was an accomplished, among other things, martial artist?
I never saw that personally.
What?
Were you aware of it?
I knew that he was a wrestler in high school.
Actually, he was on the judo team in high school, was he not?
Well, he was a state all-star wrestler, which is I'm very aware of, but I was not aware of the martial arts being a part of it.
So as close as you were, he never spoke to you about his accomplishments on the high school judo team
No, sir, more about the wrestling.
or
High
his
school
training in the
judo?
military for martial
They're
arts.
trying
The
to say
same
how
training, the military doesn't train in martial arts.
Did he confide in you the training that he went through once he left the service through the private sector in conjunction with servicemen, both active and
Not specifically, because we don't talk about that stuff if we're in really special programs.
Okay. Tell us about the physical condition Doug Benefield was in. He was built pretty well, was he not?
He was in terrible condition the night I met Ashley. He was in pain from his ejection from an airplane in the Navy that led to back surgery that year in 2017. He was not in good condition at that time. He became in good condition after he bought the device that I am a master trainer in, and it brought him back to health. He was in very good condition when he was regularly going to the CrossFit. I'm sorry, I don't mean CrossFit. Some fitness facility called Iron Tribe, which is a Christian-based workout facility. And I believe the
was
last
very
pictures of him on
religious.
Facebook are in that gym. He was in very good shape at the end.
You saw the pictures.
Yes, sir, I've seen the pictures.
Okay. Now, you've told us that he was, I think the words that you used, Mr. Benefield, was starstruck with my client, Ms. Benefield.
Yes, sir, I would say that.
You're married,
Yes, sir.
happily so.
I'm very happy.
How many years?
Just over 4.
Do you own the weapon, a firearm?
Objection
Struck.
relevant.
All overruled.
I own firearms, but I do not have a concealed carry permit like they did.
All right, and you're familiar with firearms from your time in the Navy, I trust.
Less from the Navy than after.
Okay. Have you ever fired a firearm inside your home?
That's
Intentionally?
what the brother did.
Not intentionally or
That's what her husband did.
Did your cousin Doug ever tell you that he admitted to firing?
Objection, Judge. This is part of what we were not going to get into.
So the objection is relevance?
The objection is relevance and that there were certain complaints against that this defendant made against the victim that were denied by Judge Moreland in a hearing. And this is
No,
Okay.
I thought
So is there a
he
written
admitted
agreement
to
not to get
this.
into this and that written agreement delineates everything,
No,
or is
but
this?
I thought we were not going to get into the specifics about it. other than it was shooting into the ceiling.
Well, I intend to stay within the four corners of my motion, but I think it's a fair cross-examination based on what he's testified to, his intimate knowledge of Douglas Benefield.
Okay. I don't know. I don't know what the agreement was to get into or not get into. I don't know what the relevance of this is going to be. It may be relevant. It may not. But again, I don't have to unring a bell with the jury here. So for now, I'll allow it. I may decide later it's completely irrelevant. I don't know.
And then he'll choose to
May I?
ignore it.
Yes.
Have you ever fired a firearm inside your home intentionally?
No, sir.
Have you ever considered firing a firearm inside your home intentionally to intimidate your wife?
Objection,
speaking-
relevance of this question.
Hold on. Let the question finish. Let the question finish. Go ahead. But, sir, hold on. There's going to be an objection.
Yes, sir.
Go ahead and finish your question.
to
Just didn't want the
intimidate your
judge
wife
to
into
know.
Not speaking any further.
Go ahead.
What is the relevance of whether he
I just need objection relevance sustained.
Did your cousin ever share that with you?
My
Objection
cousin,
hearsay.
Overruled.
my cousin admitted both privately.
Is the answer yes?
I would like to answer your question and be very accurate, sir, like I've been all along.
I understand. However, Mr. Benefield, this is
Yes, sir.
cross-examination.
Yes, sir. He inadvertently fired a gun in his home.
No, he testified under oath that he intentionally fired.
Objection is there a question?
Improper impeachment. Go ahead, sir.
Did
Stay.
he ever acknowledge to you that he intentionally fired? the
No, sir, he did not.
Did he ever tell you that he threw a loaded gun at Ms. Benefield?
Perhaps we talked about that. I don't remember that specific event like I remember the inadvertent firing.
Did he ever acknowledge to you that he punched the dog in the face so hard that it rendered the dog unconscious?
That's not what happened in his story to me.
Were you there?
No, sir. You asked me if I talked to him.
Did he ever acknowledge to you that he punched the dog in the face so hard that it knocked the dog out?
He admitted hurting the dog, but that's not a detail I remember.
Is the answer to my question no or yes?
Would you
Yes
restate the
and no.
question, please?
Did he ever admit to you punching the dog in the face so hard that it knocked the dog unconscious?
No, sir.
Did he ever tell you that he regularly carried a loaded firearm?
Of course.
And to be clear, it was a firearm that was also cocked. All that was necessary was to pull the trigger.
I don't remember that detail, but I'm sure that he carried it appropriately or he wouldn't have carried it.
Okay. You don't know whether he carried it wrapped or not.
No, sir.
Did he acknowledge to you that he placed a tracker on Miss Benefield's car?
No, sir.
See, now we're getting all
Did
the
he
details.
acknowledge to you that he was caught at night by a neighbor peering into
Objection,
Miss?
Judge. Counsel is testifying just to find out if this witness has the information.
Correct.
If he
So
wants to call a witness, fine.
Your Honor, he's testified.
hold on. The way cross-examination works.
Yes, sir.
Is that the attorney is allowed to ask this question.
Yes, sir.
Generally, it's going to be yes or no. If you can agree with it, you agree with it, and then you agree with it in total,
Or not.
or no.
Yes, sir.
And if it's a question about do you know, you know or you don't.
Yes, sir.
And state, I understand what you're saying on the counsel's testifying. That's another issue. Obviously, if there was a jury here and so forth. With me, I'm not going to be influenced by the question. The witness can say, yes, that's true, or no, it's not. I know that. I don't know that. So go ahead.
Thank you, Judge. Did he admit to you and acknowledge that he was caught by a neighbor of Miss Benefield's at night, standing in the neighbor's yard, peering into Miss Benefield's window?
I don't remember that from him.
Is that something that you think you'd recall?
Yes, sir.
Is that something that you would expect of the Douglas Benefield that you knew as well as you did?
It's a possibility, not a regular habit of his.
Did he acknowledge to you, Mr. Benefield, punching holes in the drywall of their home out of anger?
I'm aware of one, not many.
And finally, did he acknowledge to you beating up his first wife, Renee, on their honeymoon?
I'm not aware of that.
When he lived here in Bradenton, Mr. Benefield, I want to be clear about something. At no time, to your knowledge, did he live in the same residence as Miss Benefield.
I know that they were on the lease together in the final apartment, but I don't know if they ever were in the apartment together, but they were on the lease together.
Okay, so my question to you is, did he reside in a separate apartment here in Bradenton?
He had an apartment in Bradenton. Yes, sir.
I don't believe I have anything further.
Yes, sir. Redirect.
Your Honor, give me one moment.
Yes, I was going to say, if you need a moment, go ahead and do that. Hold on 1 second.
It states that once hearsay has been admitted and allowed by the court, the opposing party is entitled to move into evidence any testimony of the witness referred to, the non-testifying party, that exists. So in other words, during the state's examination of Mr. Benefield, wherein hearsay statements were allowed, the defense is entitled under 806 to move into evidence the entire statements of any prior statements made by Mr. Benefield, the deceased. If the court will take a look at that rule, I'll rise it. I'll address it later on.
Okay, so the doctrine of completeness? The doctrine of completeness?
Yeah.
for that particular
It's
statement.
actually separate from the doctrine of completeness, but pretty much the same thing. It basically says when hearsay is allowed, the hearsay statement in any capacity or any statement of the non-testifying witness may be admitted into evidence by the adverse side.
I guess it'll just depend on what the statement is and when it was made and the relevance and sure.
Yes, I'll address it with the court at a later.
Okay. Yes, ma'am, redirect.
Just for the record, Judge, I completely disagree that that's what 9806 says. And in my direct examination of Mr. Benefield, I was very specific to only get Ashley's comments, not Doug Benefield's comments with reference to hearsay. So just that would be my response to that. So the defense asked you about this punching a dog issue.
Yes, yes, ma'am.
And you said that's not the story I got. What was the story you got?
The story I got was that Doug was sitting on one of his chairs with an ottoman. He always wore short shorts,
She's getting it in now.
bare-legged sandals, just like the night he was killed. And the dog jumped up in his lap because the dog was I picked up the dog after his killing. So I'm very familiar with Sully. Big dog, big nails, jumped up in his lap. And he was frustrated and it hurt. Aggressively pushed is what he told me.
Okay.
He admitted that was more than he wanted to do to the dog, but it was due to his frustration at the time. He pushed the dog off of his lap because it was cutting into his legs.
So at no time did he say he punched a dog?
No, ma'am.
At no time did he say that the dog went unconscious?
No, ma'am.
And the defense asked you if you were aware if Doug told you that he put a tracker on the defendant's car. Were you aware of that?
No, ma'am.
Okay. The defense also asked if you knew about Doug punching a hole in the wall.
I knew about one punch.
And what was the reason for that punch?
Frustration.
The defense asked you if Doug regularly carried a firearm. Did Ashley regularly carry a firearm?
Even the first night she met him in front of Secret Service in the area. Yes, ma'am.
So did she have a concealed weapons permit?
I understand she does.
And did Doug have a concealed weapons?
Yes, ma'am.
No further questions.
Mr. Benefield, where did you obtain the explanation about what happened to Sully by your cousin?
Both from Ashley and Doug.
Your Honor, now, again, I would direct the court's attention to 806. And briefly, if I may, Your Honor, I'll read to the court why I believe it's appropriate. Attacking and
We need to hear this.
supporting credibility of declarant. When a hearsay statement has been admitted in
No,
evidence, credibility of
he's
the
just
declarant for
saying
those
that
purposes,
he
if
wants
the
to be able
declarant
to get in the statements of the brother. I mean, of the
Okay.
husband, his
had
cousin,
tested inconsistent with the declarant's hearsay statement
Let's
is
see
I don't
what
wonder
admissible,
if the judge
regardless
left
of
it
whether
in.
or not the declarant has been
I can go to
afforded.
his decision.
I don't know what are we
Judge, Your Honor, conversations that took place in the court of
argument on it? Which specific statement was it?
I believe, among other things, Mr. Benefield testified to everything relating to the ballet. I believe he testified to statements about how enamored Douglas Benefield, the deceased, was with Ashley Benefield. Those hearsay statements alone, Your Honor, open the door to 806, so that any statement by Douglas Benefield that is inconsistent with that testimony is admissible.
I don't remember any statements where, you know what, this would probably be better. So we're talking about your testimony.
Okay.
I'm going to excuse you to the
Yes, sir.
hallway.
No worries.
The rule of sequestration has been invoked.
Yes, sir.
That's a rule here in the state of Florida. Probably the answer invokes. Right, the witness has stepped out on that.
So it's
particular-
clear from this hearing that some pretrial like motion hearings, the hearsay rules don't apply, but it's clear based on their argument that it does apply here. And he's trying to basically not object to hearsay so that he can turn around and argue that I'm getting every statement this guy ever made under the sun. Now, the one thing she did not ask, she being the prosecutor, did not ask this witness about when she was, redirecting him, was what did he say about shooting the gun in the air? Now, he did. So it wasn't the opponent who offered it, because the defense himself asked that question and asked if he told you that it was that he did it intentionally, and he's arguing he did it inadvertently. So he's not going to be able to use this rule for that. He wasn't really able to impeach him on that because he could have lied to the cousin when he said it. So it's not impeaching the cousin's testimony. It would only be impeaching the deceased's testimony. I feel like there's some other rules of evidence that he could have gotten this testimony in under, especially for this hearing. But let's see what the judge says.
Before we do, I got to thank Susan Lupo. Always Giver just sent me $20. Cash App, Susan, you're the best. Thank you. Also have to thank Deja, who sent some treats for the dogs, and QB Designs. Thank you guys so much.
Point. Just clarified, how do you know that? Did he say it? Was it your observations? So I don't think that's necessarily a statement. What other statement in
that was
particular? There's one I overruled. I didn't see it as being offered for the truth of the matter asserted, so I didn't see it as hearsay.
Sure.
I know there's one of those.
My objection was on the basis of hearsay.
Mhm.
The court allowed it. And I think if you will, the danger of 806 and why it can be a two-edged sword is that it does not restrict the subsequent admission to anything relevant to the hearsay statement that is allowed. It rather sets up the credibility issue. And once a hearsay statement is allowed into evidence, then any other statement that the declarant made that is not available is admissible if the question is we're told. If I have to say
Here's exceptions, and somebody might object to hearsay. Overruled doesn't tell you if I overruled because I don't see it as hearsay. It was a statement, but it wasn't offered for the truth. Could be that I went through the catalog of exceptions and found as one of those. So I wouldn't read too much into overruling a hearsay objection.
sure, and I understand.
And 806, familiar with it, and it's when a hearsay statement is put before the prior fact or into evidence, that the hearsay declarant's credibility can be attacked or supported as allowed by the rules. I don't think it kicks open the door to any possible hearsay statement the declarant ever made on any topic at all.
Respectfully, if it
Ditto.
goes to the declarant's credibility, I would say it does. And I think that the statute and the case law will support that because again, it's not tied to the
Oh, no, I
relevant.
didn't say credibility. I said any hearsay statement. That's what I'm hearing, is that we can bring in any hearsay statement.
To the extent it supports.
I don't know why he just
an
doesn't tell him
attack
what he wants
on
to
the
put in.
credibility. Yes, sir. Yes, sir.
That I don't disagree with. A hearsay declarant's credibility can always be attacked or supported pursuant to the rules.
Right. So it's our position then that any hearsay statement that supports our attack on the credibility of the declarant is admissible. And specifically in our motion, we have several of them and we appended them as exhibits. So I think that they are now admissible by virtue of 806.
I'm still not sure exactly which ones you're talking about, but state.
And Judge, I'm confused because that once a hearsay statement comes, by the way,
All right, this
Into
is,
it. You're gonna we got it's limited. All right.
thing, but that would be
If things may be relevant or not relevant.
this is good legal
Back-
stuff,
yeah,
but this is not giving us background
yeah.
on
No.
Ashley.
Hearing
I
is
agree.
without objection. We're not gonna have hearsay. State.
Judge,
Arguing comes in, he won't discuss about it from. So Mr. Benefield is done.
Yeah.
Released from their subpoena. Benefield knows.
Stephanie Murray.
The truth, the whole truth, and nothing but the truth.
Where did I put my notes? Hello, ma'am. My name is Judge White. I'm going to be presiding over this hearing.
I think
As the
this
deputy
is
said, about 12 to
the
15 inches from that
deceased
microphone.
lawyer, family lawyer.
It adjusts up, down, left, and right to wherever you need it comfortable. And if you just
Maybe,
need to allow-
maybe not.
Name,
Stephanie Murphy.
and what do you do for a living?
I'm an attorney.
What type of law do you practice?
I practice family law.
There you go.
And do you work for someone or are you self-employed?
I'm self-employed. I have a firm in Sarasota.
How long do you have that for?
I've had the firm for approximately 15 and a half years.
And were you hired at some point by Doug Benefield?
Yes.
Do you recall when you were hired by him?
I first met with Doug Benefield on March 13th, 2018. He retained me on a partial retainer the following day on the 14th of March.
And what was the purpose of him hiring you on that day?
On that day, I was retained for a limited purpose of communicating with Ms. Benefield with regard to the upcoming birth of their child.
Okay, so the defendant was pregnant at the time.
Correct.
And do you recall when her due date was?
I believe the original due date was April 8th of 2018.
And you said your initial responsibility was to communicate with her.
Yes,
So did you attempt to communicate with her?
I did. I sent her a letter via email on March 15th, 2018 at approximately 9:59 in the morning.
And without getting into all the specifics in the letter, basically what was the gist of it?
The general gist of the letter was that with knowledge of the upcoming birth of their child, Doug wanted to express his interest and desire to be part of the birth process, to be present if possible, but also wanted to communicate that if Ms. Benefield felt uncomfortable about that, he wanted to respect her space.
Runner for the record, object to hearsay and relevance.
Yeah. Is this being offered for the truth?
No, it's just basically
The verdict came in the Tyler Daisy case. Simon Cat.
being offered to show that this is how the communication
And it was
started
guilty,
that
right?
there was suspect.
It was guilty
you were
and
informed of
very
that?
quickly.
I'll just say, I was not taking this as for the actual truth of this.
Oh, the hearsay. Let's just hear what this lady has to say, for Christ's
But
sake.
in what form did you send you? Did you ever, let me back up. I don't know if you said this, but in what form did you send her this communication?
It was a letter that was saved as a PDF that was emailed.
Did you ever receive a response from her?
She never responded to me directly, no.
To your knowledge, did she ever respond to Doug?
No, not at that time.
At some time shortly after that, so the baby was born in, or when was the baby born?
Well, baby was actually born quite early. The next day after receiving my letter, she checked herself into Tampa General Hospital and then started a induction of labor process. And so the baby ended up being born about 3 weeks early, I think March 19th of 2018. I may be off.
I'm sorry, but you can't
Correct.
force a doctor to induce labor 3 weeks early. If that's clearly what she's getting at. No doctor is going to induce a baby unless there's some stress to the child. I mean, that's my opinion.
Yeah, I think I think you're right.
Was Doug
They're
there?
certainly not
No,
going to do
he's
it
not
because
there.
they
I
got
had
a
no
letter
idea.
from
Baby
their
was
attorney.
born.
Did the defendant file for an injunction shortly after?
Yes.
And what date was that?
My memory is that it may have been, excuse me, May 1st of 2018. It could have been in April. There was a bit of a lag between when she filed it and when we had knowledge of it because the injunction was actually denied, but a hearing was scheduled. So Mr. Benefield was not served.
Okay, so just to be clear, you said the injunction was denied. Are you saying the temporary was denied?
Correct.
Okay, so an injunction was filed, a temporary was denied, but it was set for a hearing? Is that what you
Yes,
said?
that is correct.
All right. Do you recall when the first hearing was set approximately?
It was shortly after we found out about the injunction. So I think we found out, meaning I found out on May 6th of 2018 that the injunction had been filed, which is how we knew that the baby had been born and what the baby's name was. And then the hearing was originally set for shortly after that. I think just a couple of days.
Okay.
Ended up getting continued anyway at Ms. Benefield's request.
Okay, so it was set pretty close in time, but it ended up getting continued.
Correct.
Before the hearing was actually held, did you end up filing something on Doug's behalf?
Yes, quite a few things.
And generally, what did you file?
Generally, it was a petition for a parenting plan unconnected with divorce and a motion for psychological evaluation. Those were the initial pleadings that we filed.
Ultimately, were these issues all to be addressed at the same hearing?
Ultimately, yes. Well, let me clarify. No, because then when the hearing ultimately took place, it wasn't the original petition for parenting plan unconnected with divorce. It was actually an emergency motion for a temporary time sharing and parental responsibility. But both cases traveled together. And so pleadings or motions in both cases were heard at the same time.
Okay, so while the motions themselves may have changed, the two case numbers were heard at the same time.
Correct.
So at the time, Doug had an emergency motion for time sharing?
Yes.
And what, just briefly, what is that?
When there's a child, there's no such thing in Florida as custody anymore. Parents have time sharing with children. Ms. Benefield was withholding time sharing of their daughter from Doug. And so the appropriate way to seek time sharing was through the court versus taking matters into your own hands.
Okay.
He was also seeking parental responsibility, which is the decision making.
Okay. And when was that hearing held?
It was held on 2 different days. It was July 30th and September 17th of 2018.
So you did have part of the hearing on July 30th, 2018?
Yes,
And did not finish, I'm assuming?
we did not finish.
What judge was it?
It was Chief Judge Diana Moreland.
And before that first hearing, was there a motion to recuse the judge?
It was a motion to disqualify Judge Moreland.
And was it granted?
No, they appealed that decision and filed a motion to stay pending appeal. That was also denied.
Okay, so the hearing continued.
Correct.
Then,
You're establishing she was trying to
The
delay
rest of
that
the hearing
getting
is-
heard
Yes.
so that he didn't see their child during all that.
Sure sounds like a lot of shit going on this divorce.
so I don't want to get into the specific facts of the allegations in the injunction, but if you could just tell us generally, what were the topics, the injunction?
It was a wide range of topics. The most alarming was she had allegations that she was poisoned by heavy metals and that the baby had also been poisoned in utero. She alleged violence of the dog.
Oh, I'm sorry, I thought we were going to talk more about the poisoning. So
Okay.
violence with a dog.
Correct.
poisoning.
Right. Threats, and that he had discharged a gun in the home.
So those are her backbones to why she was so
After this
fearful.
hearing, did Judge Moreland make a ruling?
She made a ruling at the conclusion of the second day in September. Yes.
And what was that ruling?
Her ruling was
I'm going to sustain as to her ruling on these issues. I mean, I'll hear.
And-
Go ahead.
I'm sorry.
Put whatever you want on the record.
This we may need to have argument about, Judge. It is my argument, it's the state's argument that the content and the manner in which, I have the order recorded, the judge made this ruling set the stage for the defendant's behavior later on down the road. Because she knew that this judge felt the way she did, and she had a hearing in front of this judge 3 days after she murdered the defendant. So I think it's effect on the listener, and I have some case law we can argue if you'd like, but this manner in which this order was given is highly relevant to the defendant's, the
State of
effect
mind.
on her.
All right. So you're not introducing Judge Moreland's ultimate order to influence one way or the other to prove that it was correct.
Correct.
It's the effect on the defendant.
Correct.
All right.
Whether it be right or wrong, the ruling, I'm introducing it for the effect on the defendant.
Yes, sir.
I don't have a problem with that. The problem that I have, which I think the court is well aware of, is the characterization of the presentation.
Right, absolutely. If it was for the purpose of, hey, Judge, this other
No.
judge ruled this way, therefore, that's
I
what
didn't
we
say
want.
family
But-
lawyer's no longer alive. I didn't mean to.
If it's to show the effect, and yes, that one of the cases you had submitted illustrated that very point. So I get that. All right.
I want to make sure we're talking about the same thing. I don't have a problem with the state's theory that this decision prompted the subsequent. What I strenuously object to is the statement by Judge Moreland, the characterization of the quality of the hearing. That I think should not be stated in this proceeding. I think it's irrelevant. The decision itself, I don't have a problem with. I can tell the court, well, let me just leave it right there.
All right. I don't know what the statement is. I'm going to have to hear it eventually, and then I just won't consider it. But it was, yes.
So they're
Flippity
doing
flip.
that just so we can't hear. There's no reason to approach the bench in a pretrial hearing. There's no jury there.
And as it invariably happens when you introduce new hardware into a system,
All right, well, let's see where this is going. All right.
In Illinois, we call it parenting time, not time sharing.
all right, welcome back, ma'am.
Thank you.
Do you have any trying to discuss the case with you or anything about your testimony?
No.
All right.
Oh,
Where
if she was in the
Judge
room,
Moreland made
that's
a
why they would need to go
oral.
Correct.
sidebar.
The oral ruling at the conclusion of the hearing.
And was the defendant present to hear this ruling?
Yes.
She was in court then.
Yes,
All right. I'm going to show you State's Exhibit number 1. Do you recognize that?
I do. Those are my initials.
What is it?
That is the CD of the oral pronouncement at the end of the injunction and emergency time sharing hearing.
And you said these are your initials. So
Correct.
when you listened to it, did it accurately reflect your memory of what was said in that hearing?
Yes.
State and enter in evidence.
Not accepting it for the truth.
Someone else investigated this, so there's that one thing.
And then the state will publish it's about 10 minutes long.
Mr. Sessions start with that one thing, even though I find it very reticent to ever say, well, someone else
No, let's
investigated
slow
this.
this
so
one down
I'll
because
feel
this
free
is
to
going
take
to
it.
be.
Mr. Sessions argues that people investigated and found that his client wasn't the perpetrator of any domestic violence, etc. Because I just read a report by a doctor that just indicated that he had done a full battery of psychological evaluations on Mr. Benefield in this case. He had absolutely no concern of self-harm, domestic violence, or any other type of spurious activity on behalf of Mr. Benefield.
What?
Let me just go ahead and say as follows, that this court will find that as far as credibility is concerned, I would find, and I'm going to say this in the gentlest form I possibly can, that there is absolutely not a single scintilla of credibility that I'm attaching to anything that was testified to, at least in this hearing of Ms. Benefield.
You know, when they say scintilla, they're letting you know that she didn't believe a fucking word that Ashley Benefield said in whatever that hearing was.
Court finds that it starts from basically the absurd of
Sniper wrote the
conversations of
same
what
thing.
she would have had with a child, searching the room, finding a shadow box, being so upset, but also at the same time the testimony where she said, well, they were absolutely liked me a lot. They confided in me every conversation. I knew all these horrible things were going to happen because the girls felt good talking to me. We then move forward to the actual presentation that she's had in this courtroom since she entered into this courtroom, the turning on of tears when she thinks it's appropriate, and then we move on to the entire insinuation that there is some type of poisoning going on in this particular case. There is not a single scintilla of credible evidence that Ms.
This
Benefield
cannot get in a
has
trial.
ever been poisoned or suffered from any illness of any poison. Court finds that Dr. Hilliard's testimony was
Subjective.
suspect.
Oh,
I don't think
Suspect.
that the court finds that he reviewed one record appropriately. And in comparison to Dr. Sawyer, I think his testimony, in a word, was bunk. I do find that Dr. Sawyer's testimony was quite informative and that his information concerning the answered questions that I had, how there were testing for certain metals on and then testing for certain metals that weren't there. It's most important to this court was the explanation of the misinterpretation or the use of an improper range, which I think even in cross-examination, there was a misunderstanding that there is a range of these metals are in the human body, not just a single number. So that brings us to the following timeline. I have that in 10/20/2016, there's the respondent goes up there. They're at the respondent's home. Petitioner is up there. He's had back surgery. She moves back to the respondent's home permanently on December 2016. That in about January 2017 through, I'm going to say 5/8/2017, there appears to be a marriage in which there are arguments. But there is still a very committed relationship to the point where they're talking about having a reversal of vasectomy to have a child. That on 5/8/2017, the clear evidence is that there is the vasectomy alteration or reversal. And that from that point, they begin to pursue having a child. The court will find there is one incident of alleged domestic violence. And I got to tell you, it is de minimis, even though it's huge whenever how it was executed, the shot into the ceiling.
De minimis.
Going to find that at no time was the shot by Mr. Benefield at or in the direction of Miss Benefield. The court has seen Mr. Benefield testify, and the court finds that Mr. Benefield is taking on responsibility for that single misstep. But that is a remote type of domestic violence that has occurred. Subsequent to that, it is clear that Ms. Benefield continued to pursue a relationship and to have child with this gentleman, that she had a lavish wedding, invited numerous people there, had many people that she could have confided in, saying, I'm in a hellish situation, things are out of control. Just last week, he shot a bullet in the ceiling. That's absolutely not what happens. Instead, she goes through with this lavish wedding. She goes on developing a ballet with her husband at that time, posing in magazines, portraying to everybody in the world that this is a very happy.
I can't believe this.
We're going down. We're going to start this national ballet at a significant cost, both emotionally, physically, and financially to the parties. That she finally they finally find out that in July 2017 they have conceived a child, and that or they think that that's the date they've conceded in retroactive review, which tells this court that during that period after the shot, that they were still engaging in a intimate relationship. The court does not find credible any type of animal cruelty in this particular case, nor does the court find that the other incidences alleged of punching the wall were ever directed completely at her, nor were they meant for intimidation. Court's also going to find that at 3/2017, they do find about the pregnancy. It's confirmed. And at that time, because of illnesses due to the pregnancy, it is determined as a family, as well as because of the ballet, that they're going to move Miss Benefield to Florida from South Carolina. During all this period of time, what we have is a household that is continuing on. Miss Benefield being in the home, not making anyone alert. The medical records are devoid of any conversations between her and people that would have been providing protection, those being doctors, etc., indicating in the least that she has any type of poisoning that is appearing in her system, that she has been the victim of domestic violence, and or that this child, Eva, has been the victim of domestic violence. Then we go on, and suddenly we have, she moves to Florida, but even in Florida, we have Irma come through, I think September 11th, that weekend. Mr. Benefield comes all the way down. He makes sure she has a generator she needs for the storm. He then leaves, and she feels comfortable enough and well enough to go all the way back up to the home that she shared with Mr. Benefield to collect property and transport those items down to Florida for her own use, and without any fear that this gentleman is going to harm her when she's up there. One of the other things allude to as far as credibility problems were the issues concerning the split records that she's asking the Lakewood Ranch to have to, I guess, somehow cover any type of problems or contradiction there might be with the poisoning allegations, as well as the emails that were introduced today between the cousin of Mr. Benefield and Miss Benefield, I guess, trying to curry some kind of upper hand in the in either of these two cases against Mr. Benefield. Court's also going to find that the wife has at this time demonstrated a complete disregard for allowing Mr. Benefield to have any active role in the birth of his child and or the life of his child that he has now not had any contact with. Court's going to find there's been no violation of any injunction. The court did look at and has listened to the testimonies that were provided concerning the injunction that was entered. Quite frankly, it sounds like the court was, when you listen to the transcript, was actually telling both of them they needed to stay away from each other. And that certainly there was no violation of it whenever there was the oral pronouncement, only to be followed by a written pronouncement. Court is also finds there are some issues with the credibility of Miss Benefield when she's actively sitting here telling this court she doesn't like to have publicity, but at the same token, she's participating in articles concerning the alleged poison, etc. As far as the last comment on the poisoning, there is not one piece of evidence, like I said, that has been established that even if she was being poisoned, that there has been a suggestion of a nexus of the who, how, and where the poison. That would be rank speculation for this court to jump into the idea that because it happened, it had to be him, especially when
My
I have,
phone's dead, Bay.
in all senses, not a credible witness is the only person
Oh,
that's
wait, I
asked
can check my
to
text.
speculate. So with that in mind, the court is going to find that at this time, there is absolutely no evidence. And I'm saying no evidence. I'm not saying by the preponderance of the evidence standard, that hasn't even been close to that there's been a indication that there's an immediate likelihood of domestic violence. There's only the one remote incident.
Oh shit, Joe! Thank you so much. Welcome new members. Thank you, Joe.
And as of today, there's no reasonably prudent or logical person would think that you're the threat, that you're being threatened by immediate domestic violence. So for those reasons, the court is going to deny the request for an injunction in this particular case.
So after the judge's ruling.
All right,
That
so
was something,
pause
huh?
this in case.
Yeah.
So,
That was
all right.
scathing.
So for anyone who was paying more attention to the chat than what was going on or talking, this is the prosecution playing what happened in the victim and the defendant's custody case pertaining to the child that she was pregnant with, and she moved to her mother's. So the judge is accepting that the evidence to her demonstrates that she moved for the purposes that the cousin told us moments ago, like because she was having health issues and the mom was taking care of her. But then at the same time, it's as though that judge didn't really believe she actually had any medical issues, because she's like, yeah, but then you were well enough to drive back, to do this, to do that. She also doesn't believe that she was scared of this, of her husband. Now, look, I obviously wasn't there, but my guttural instinct when she is like, you took pictures with him after this, you slept with him after this, you continued a relationship, you proceeded to have this big wedding ceremony, even though you were already married. I just didn't think that on its face, okay, not knowing how she came off in court, not knowing why this judge is saying you were turning on and off the waterworks when you thought it worked for you, all of these things. I just thought that was so unfair. And for her to call him, apparently there was arguing going on in the house. I think it might have been between Ashley and his daughter, but I'm not sure because I don't know a lot of the facts. But he shot at the ceiling to out of frustration to get everyone to like shut up and to get her to stop, whatever it was that she was doing. So but like I said, I mean, I don't know. Clearly, whatever she did had a huge impact on this judge. And look, if you're the judge and you're getting the sense we all, saw it in now I didn't really watch it, but the Heard Depp trial. But where it seems very clear to everybody watching that somebody is trying to put forth pull a victim card when they're not really a victim. And clearly that's what this judge is saying. I mean, she couldn't say it any more outright. She said she was going to be as gentle as she can. But I'm just going to say on the just facial level that happens all the time when people are being in abusive relationships, that they go on and paint a pretty picture of their life all the time. Um, and like that she didn't tell anybody and all of those things, but it's very clear that the trial court judge, just like we were saying in the beginning, like it's all right, she's delaying all of this because she's trying to delay, him access. And I've seen it on the other side, when a child is born and the couple's not together and the woman's breastfeeding, they're like, you can't see this newborn baby. I'm breastfeeding and I'm the only one that can do all of these things, which there is actually some truth to, but it's very hard to find the balance when a child is a newborn, because all that bonding time, like I can't imagine being a father and not being able to have that bonding time. But, how much time can a newborn leave the mother for, especially if you're breastfeeding? I don't know if this mother breastfed or didn't, but um, she didn't find any evidence that, let alone was she being poisoned, but where the source of the poison, was. And I think that, that's even more of kind of what she is relying on. But I did say earlier when this started, like, man, this can't get in at trial. I'm not saying from a legal standpoint that it actually can't. I'm just saying it's way more prejudicial than probative, but there's also some from a prosecution standpoint. Some of it is important to show you had not a chance in hell. This judge didn't believe one word you said and will never believe a word that you said. And, so in her mind, she was about to lose everything. And the only way to avoid the husband, getting the child or getting equal time or whatever amount of time with the child was to murder him. I think there'd have to be some sort of balance, because they cannot allow this judge's opinion that she is not trustworthy to come into trial. That is invading the province of the jury. This jury needs to decide whether these things happened, whether they believe this witness. So while it's important for the prosecution, and I'm just hearing this with you, all of you, so I haven't had a lot of time to think it out, but it's highly problematic and they cannot, and I believe from a legal perspective, cannot leave the parts in where the judge is saying that she doesn't trust her credibility at all. But at the same time, there's an aspect of that is important if you're the prosecution. I can see that. So I don't know what the proper balance is, and we're not going to be able to get through all of this today. Maybe it's something that me, Bob, and Jay can divvy up, and on Monday kind of be ready to come at you guys with where some of this stood and what's going on. But I mean, so far with just these couple of witnesses, we've gotten a lot of background. A lot.
Yeah.
That right there is everything. That from the defense's perspective, that's their entire case.
Let's see.
Which would be the defendant's motion. Did she make a ruling on your motions?
Yes,
And that was time sharing with the child?
it was time sharing and parental responsibility.
Okay. And what was the order, or what did the judge say Doug could do?
There was a temporary time sharing schedule that was increasing in frequency and amount. So it started with the first day that he was going to be able to meet his daughter, just a handful of days later. After a period of time of seeing her according to the schedule, then it jumped up to weekend time sharing, overnight sharing. Then there's another jump. And so he was able to take his daughter back to South Carolina for time sharing. There was also, I believe, some extended visits, maybe holiday related, but then the other main component of that order was with regard to shared parental responsibility, which again is the decision making. And Judge Moreland ordered that Ashley and Doug were to exercise shared parental responsibility so that they would have to confer and make a good faith attempt to agree on major decisions. But the court specifically ordered that Doug Benefield would have ultimate decision-making authority regarding health-related or medical issues. And the order made very clear findings about her extreme concern with regard to Ms. Benefield's medical decisions up to that point, which is why she ordered the ultimate decision-making authority.
And the
Leslie,
concern was for the medical
agree.
decision.
I agree with what Leslie's saying, that the judge's ruling is important for the jury to hear in terms of being the possible catalyst for the shooting. It's just a very, and like I said, we'll circle back and we'll let you guys know exactly what this judge ruled and how it's going to go. Because there's got to be some kind of balance, because yeah, I agree that you almost need to know that I don't know. I need to hear more about what the next kind of steps were with this judge. I think could be a way to let the judge know, to let the jury know everything other than the fact that she found her like completely incredulous and didn't, and didn't believe a word that she said. Although depending on kind of the full picture of the the prosecution's theory of the case, that could also be very important, because you're stuck in front of a judge who will never believe another word that you say. But
did I miss that? I missed that? Did she say the gun was a remote incident? That's a major fucking problem, firing a gun inside of a fucking house.
yes, she said it was de minimis. That's why I was like
That's
outraged.
a major fucking
Like
problem.
how is that de minimis? That's why I'm describing. It's not even like he just shot it at this. It was out of frustration to get her to fall in line, whether she needed to or not. Like I don't know enough. I'm just saying I just don't know how she says that was de minimis, because it wasn't pointed in her direction, because it like that it's meaningless. It was nothing. And she said it was remote in time because of the whole, then you stood together and you guys painted this picture and you went on and you took photo ops and you had a big ceremony. So you weren't really scared of him either. Like that right there, is shocking. And like I said, I don't know enough about what would have driven this judge to say that, but it seemed outrageous to me.
Yeah, that's all of the minimus. It's not de minimis. That's all of the isses. That's some bullshit.
Decisions for the child.
Correct.
Re-minimus, unminimus,
So why
whatever
is
the
there an
opposite of
escalating
minimus
frequency
is.
of visitation with the child?
Well, Doug had never even been allowed to meet his daughter. So she was, I believe, 6 months old by the time he met her. And so it's just appropriate that you don't just dump a baby with who was at that point a stranger.
Okay.
So it was just to grow in a reunification, or unification, I guess. There's nothing to reunify.
To get the child used to who she was going to.
Exactly.
Okay.
Bullshitimus.
So the first time sharing where there was an exchange of, and the daughter's name?
Her name is Emerson Grace Caney.
Okay. And can you spell the last name?
I believe it's Caney. I have to double check my file to be completely certain.
Okay. And where were these exchanges of custody to take place?
Well, according to the court order, they were to take place at Manatee County Sheriff's Office, and that's where the first exchange took place.
Were you present at the first
Yes,
exchange?
I was.
And
So,
did you
just
arrive
pause real
with
quick.
Doug, or were you separate?
Bob put on, and it might have been the Dateline. I think I saw someone mention it. He's trying to, get some factual stuff, like last night as we were going to sleep. And we didn't know who this woman was, the lawyer on the stand. But in the first couple scenes, we were both like, "Mm." I'm like, "Unless that's his sister, she's awful protective and, like, defensive of this guy," and, maybe that can come from the attorney-client relationship, and, I hate to be just spewing my and Bob's, like, kinda just initial kinda take was like, did she have, like, a thing for this guy? And it's based on nothing, but, like, our just, like, the way she came off in, like, the very first scene, but I'll tell you, it's highly unusual for your lawyer to come with you for an exchange. Now, if you I have had clients who I am fearful, like, and let's just for a minute assume this woman, Ashley, is lying about everything. That's a recipe for disaster for him. You need to have somebody with you, or you need to have approval to have a camera on recording so she doesn't say you hit her, you threw something at her, you tried to poison her, you shot a dart, like whatever. Yeah, it's in a police and that's part of the reason why they do them in a police station's parking lot. There's recordings, but you can't hear what people are saying. So, but for her to actually go with him is to me, it's a little strange. So I just don't know how objective this lawyer is, even from the point that she's not going to be objective because she's his lawyer anyway. But it just seems a little unusual to me.
Arrived separately. By the time I arrived, he was already there. We were both there earlier than the scheduled exchange time.
And was this the
And,
first time
sorry.
Doug was meeting his child?
Yes.
She risks making herself a witness and taking herself out of the role of attorney, by the way. So, oh well, there you go, Brooklyn. My lawyer came with me for exchange for a little over a year. All right. Is this in Florida?
New York.
Brooklyn? New
Brooklyn's
York.
from New York. I think if that's when this was happening, but I know she's in New York now. But
So there you go. Not as bizarre as as I am interpreting it, but you do risk making yourself a witness if something were to happen, and then you can't even be the lawyer anymore.
Ashley ended up moving in with her therapist. What? That's what? Ashley
mean-
Benefield in with her therapist?
Clearly the whole 13 days of, marriage, it speaks. I mean, I guess it could speak either way, so I'm not going to even say it. So strike
Isn't that like
strike that from the record.
Strike it from the record. Isn't that like the show Shrinking on Apple TV? Didn't they do that? Anyway.
I mean, not allowed to do it. Not allowed to do it.
What happened during this
therapist-
exchange? Did
No,
the
no.
defendant ultimately show
Oh,
up
we
with
know.
the child?
Yes, she did.
And just explain how that meeting went.
Okay. I had been sitting with Mr. Benefield in his truck, and when he saw Miss Benefield enter the parking lot, he moved the truck closer to the entrance to the building, and she was out in front of the building with the child. Doug and I then approached Miss Benefield, and I hung back a bit, and Miss Benefield saw me.
Jan, no, we did not discuss that. You have Ashley filed for continuance of the trial today. Oh boy.
What?
Oh boy. You may not have a trial. Oh boy.
Looked at me and then immediately said, "Are you dating her?" She was very indignant, very upset. And then I responded to that question. Of course, I said no. And then they proceeded to have a conversation where Doug was trying to engage with Emerson, talking to her, ultimately was able to hold her. And Miss Benefield was in very close proximity to Mr. Benefield, probably less than from me to the judge's bench.
Wait, I missed.
Especially when she transferred the
was
baby
holding the
over
baby?
to his arms.
Oh.
Me to with, of course, I said no. And indignant, very upset. And then I responded to that question. Of course, I said no. And then they proceeded to have a conversation where Doug was trying to engage with Emerson, talking to her, ultimately was able to hold her. And Miss Benefield was in very close proximity to Mr. Benefield, probably less than from me to the judge's bench, especially when she transferred the baby over to his arms. They kept talking for 5 or 10 minutes or so, and I kept waiting also there. Then Mr. Benefield turned to me and said, "Okay, we're going to go. Ashley's going to come." And so I pulled Doug aside. We had a communication about it. I warned him that it was not a good idea, given all the allegations that she had raised up to that point. And he said that he was aware of the concerns. He agreed with me, but he wanted Emerson to be comfortable, and he thought having Ashley there, as she was insisting, would help Emerson be a little bit more comfortable. So then I watched them Ms. Benefield strap Emerson into the car seat in the back of Doug's truck. She got in the back seat and they left. I, of course, just left in my own vehicle.
So
And
I'm gonna,
approximately
let's pause
when
it
was
there.
this?
Dizzy says it was denied. Thank you, Dizzy.
So I'm just gonna make, and this is just my assumptions, my inferences. To me, that speaks volumes of who was really in control of the relationship and who in the relationship may have been more empathetic. The fact that she made all of these allegations, right? Yet he was willing to bring her along, okay, while he was entitled to his own parenting time with his child that he is for the first time actually getting to meet, I think speaks volumes to his character. Now, again, I don't know everything, so that's just that one little picture to me. It's those kind of things to me that like stand out. Something you don't fake, you don't think about ahead of time. It's not being done for a certain reason. But if he's all the things that she says he is, and now he's angry even if he's not all the things she says he is. Either way, either he's been lied about and dragged through the mud by somebody, or he's abusive and he knows it. And and he's been denied access to his kid all this time. For him to make that decision, um, it speaks to both those things. I think it speaks to his character, and it speaks to her being more of the controlling person and her ability to control.
And I kind of just want to say, I know we said in the last trial there was, well, we always say during all trials that like there's some stuff that may be triggering for you. This is like triggering for me personally because I went through a very contentious divorce when my boys were very young, and it's taken me back to I had to deal with the drop offs. I mean, I never had my lawyer with me, but we had to like meet in the parking lot, and there's always the fear that if your ex is like irrational or it's just like, so if there's anyone else who may have that kind of feeling that I'm having right now, like if you need a break, take a break. This divorce, I mean, I think about the Dan Markel when when people go through contentious divorces like this, it consumes your life. I've talked about this in other streams. It just consumes you, and you're like, I'm sure you're just thinking, what's the person going to do next? There's no break from it. There's no break from it, particularly to the point where you have to set up a meeting spot in a public place where you have to have witnesses. Like your life is just consumed with this stuff. So,
And before we go back, and I was trying to find the person who just made the comment, and I'm not gonna, maybe you'll find it once I say it, but that abusers can be charmers. And oh, it was Jam Pots. I have to say, when I was listening to the judge give her ruling, the trial, child's custody judge, that's all I was thinking about. But like I said, I didn't hear it, but I'm thinking, geez, do you know how narcissistic abusers can be? The worst are the ones that is definitely a characteristic of them being charming and coming off as charming, and trying to make it look like the other person is always the crazy person. So I agree with that, Jam Pots, and I understand that that's a definite thing, but it's this type of thing right here where it's not about really charming, because there was no one he needed to charm. His lawyer's telling him don't do it, so it wasn't like he was making a decision to appear a certain way for anybody. He made that decision because either he wanted to give in to Ashley, or because he thought it was best for his child. I mean, I guess you can make the argument, or he just really wanted Ashley around, but and maybe that's a way to look at it too. But my instinct from that, given the background, the fact that the lawyer's there, the fact that the lawyer's trying to talk him out of it, that it seemed like it could speak to him. But again, I don't know a lot of the facts, and that was just kind of my guttural response to that kind of scenario. So let's.
Tiff Knox, it was your birthday. Happy birthday, Tiff Knox. Hope you had a good one. If it's today or
Happy
yesterday,
birthday.
I think yesterday. Hope you had a good one, Tiff.
This was September 21st
September 21st of
of 2018,
2018.
just a handful of days after the hearing.
So from this point on, at least from your perspective as the family lawyer, was there sort of a peace between the two?
Well, there was. In fact, they had an agreement that we memorialized into a joint stipulation to expand the time sharing that Judge Moreland had ordered. So within a handful of days after seeing his daughter for the first time, Ashley and Doug had a written agreement signed by both attorneys and submitted to the court that said you get to see the child even more, exchanging the child anywhere they agreed. If there was no agreement, the exchange default would be at the Manatee County Sheriff's Office, but more frequently, not supervised by her. And that then was the norm for quite a while.
And how long did that last approximately?
About 11 months, I would say. From September of 2018 until August of 2019, they were together all the time. They were Doug's time sharing was always with Ashley present, so they were certainly behaving as a family. They were quite active on the social scene.
I was going to say, did you ever see them?
I did. They were in magazines. I think they were even in SRQ magazine at some kind of ballet gala event together.
So at some point, this piece did not last.
Yes, it did not last.
About when did things start to go downhill?
Unbeknownst to Doug, they were about to go downhill in August of 2019. He was scheduled to move in with Miss Benefield and her mother. So he'd kept an apartment or a little condo here in the Sarasota area, but his lease was running out. So they had agreed that he was going to move into their home. They moved all of his things inside to their home, emptied the storage unit of his contents into Miss Benefield's home. And the day he was scheduled to move in, as he always said, she ghosted me. She didn't answer the phone. And so I think it was August 16th of 2019 was the day that he was supposed to move in, and then suddenly everything changed.
Okay. So
Just for the record, you want to continue an objection to hearsay and relevancy.
Yeah, we're getting pretty in depth with this whole situation.
okay, and I can move along.
Okay.
I was liking all this
So
detail.
at some point, did Ashley start filing complaints
Yes,
against Doug?
yes, she started again. Yes.
And how many complaints were there, if you recall?
I would say a half dozen. They started, I think, in December of that year, and then they just kept on going for another 4 or 5 months. Oh, and there were complaints about the child.
Okay.
They were
So
not about her.
not about her, complaints of abuse of the child.
Correct.
Okay. And at some point, did Ashley file for another injunction?
Yes.
And were you involved in that process?
Yes.
I'm sorry, as a part of that investigation concerning those complaints and that request for an injunction, was a psychological evaluation ordered?
It was not ordered by the family court, but there was a psychological evaluation that was put into place through CPS. And I believe it was Detective Moreland.
Okay. So at some point, a psychological evaluation of both Doug and Ashley was ordered.
Yes.
And to your knowledge, Doug participated in that.
Oh, yes.
Who was that doctor?
Dr. Brad Broder.
At some point around this time, did Doug file for divorce?
He did. In November of 2019, we filed a motion for leave to amend and then a amended petition for dissolution of marriage.
Was that your case number? Did it run along with her injunction case number as we talked about before?
Yes, they were companion cases.
Companion cases?
Yes.
Okay, thank you. When was it set for a hearing?
Again, it was a hearing that was set and then moved a couple times. So I think it was originally set for hearing in May of 2020, moved to August, and then moved to September of 2020.
And do you recall the date in September?
It was scheduled for September 30th,
Okay.
2020.
Were you ordered to mediation first?
Yes. At Ms. Benfield's request, she filed a motion for mediation. The court entered an order of referral to mediation.
And during the mediation, were you
Mary,
present
that
at the
is that is
Yes,
also
we
true.
were present via Zoom, but not in
Alternative
person because it's
true.
during COVID.
mediation? Okay, but the defendant was there
Oh.
via Zoom,
Yes,
and Doug was there via Zoom,
yes,
and the mediator.
yes. As well as Ms. Benefield's attorney was also present.
And who was that?
Faith Brown, at the time, she had been let go from her prior attorney.
Okay, so What did Ashley say at the mediation about their relationship?
Both of them said,
Sustained.
What did Ashley say? It's a defendant.
This is during a mediation? Is there some exception? Mediations are generally private and confidential.
I can move on. I thought it was a hearsay. You're saying something else.
No, I'm assuming, you tell me what your objection is.
Objection, it's.
Okay.
Yeah, I mean, I don't, unless you have some case law that there's an exception to the general, I'm going to say secrecy, but the
Negotiations.
privilege, mediation privilege. I'm not aware of any case law, but you may have some that there's an exception in a criminal prosecution.
I do not, Judge.
And there
I'll-
might be. You
Um,
might be able to find something though.
At some point after the mediation, did Ashley agree to drop the injunction?
oh, she had agreed to drop the injunction before the mediation, but it wasn't just that she was going to drop it. It was a quid pro quo situation
And what was the quid pro quo?
that he dismissed his divorce case and again, another emergency motion for time sharing for the parenting plan, and the joint motion to release the psychological evaluations conducted by Dr. Brad Broder.
Okay. And in fact, were those things all dismissed except for the psychological evaluation release?
They were not.
Okay. The hearing that was set for 9:30, what was to happen at that hearing?
There had been a lot of discussion leading up to that, and the plan was that the September 30th hearing would not be held on the injunction, because the agreement was that once the psychological evaluations were provided, then the injunction would be dismissed and the family law case would be dismissed. So the 30th hearing was supposed to be the joint motion for release of psychological evaluations.
Man. So she really didn't want her
And
psychological
what day was Doug
evaluation.
murdered?
So that he was murdered on Sunday, September 27th, 2020.
3 days before this hearing was scheduled.
3 days after the mediation, 3 days before the court date.
And who
Wow.
was the judge scheduled to be at this hearing on the 30th?
Chief Judge Diana Moreland,
So the same judge that had heard the rest.
same judge.
Wow.
In all of the times that you dealt with Doug, did he ever have what I would term like an overly angry demeanor towards Ashley in your presence?
No, which is kind of a source of conflict with Doug and I, actually. He was very passive, very accepting, and always looking for
That I don't give any
excuses or
weight to.
reasons. Not angry. Just surprising. He was also very suspicious of her, but never angry.
Okay. And did he always blame her for everything, or?
No, not at all. I think he often blamed Dr. Hildegard Staninger, who was related to the Carlson labs, who obtained, involved with the poisoning allegations and the lab results. But no, not always Ashley. He was always trying to look for
So
some explanation as to
it's-
her conduct.
it sounds like, at least from what she's saying, that he believed, that Ashley believed, a doctor who told her that she was poisoned, and that Ashley wholeheartedly believed that she was poisoned because the doctor told her. I mean, we don't know enough about it yet from what we've heard thus far. But I mean, I guess that's the other side of it. It was something, at least he portrayed a belief of, to her.
Thank you. I have no other questions.
Thank you.
Cross.
I think that's probably a good time to end the stream. I think we got a lot, like you said, Ellie. We did get a lot of background with it. Unless you want to, I mean, because we were thinking like 5:30, but if we do another stream, I'm sure we can get, because I'm sure the cross is pretty extensive. Oh, maybe not. Is it? What do you think, Ellie? Do we keep going, see the cross?
I
or
mean,
do
if
you wanna-
the cross is extensive, then we can definitely pick it up.
Oh,
next
it's actually
time.
not that bad. It doesn't look like. All right, let me play it.
Good morning, Mr. Taylor.
You practice family law,
I do.
and you've been doing it, I think you told us, approximately 15 and a half years you've had your own firm?
I've been practicing family law for approximately 21 years, but I've had my own firm for about 15 and a half years.
Okay. And in the course of your practice, have you had the opportunity to represent both petitioners and respondents in domestic violence injunction actions?
I have.
And have you represented them Ms. Murphy, strictly in family court, or have you also continued in representation in those cases where the disputes end up in criminal court as well?
Only in family court. I do not practice criminal law.
Okay, so on those occasions you were referred out.
Yes.
All right. It's the nature, is it not, in family court matters that the litigation is often, shall I say, spirited?
It can certainly be the case.
Okay, it's not unusual.
It's not unusual.
Would it be fair to say that the litigation can sometimes, depending upon the parties, be quite aggressive?
Never to this level in all of my 21 years, but it can be aggressive.
All right.
This was extreme.
And it can also be determined, can it not?
I'm afraid I don't understand that question.
Litigation, in general, in family court matters.
Determined meaning,
Determined meaning neither side lets up. You have two people who fundamentally develop a real dislike for one another, and they just pour their heart and souls into the litigation.
yes, unfortunately, that happens.
Yeah, you know, they shoot more family lawyers than they do
You
criminal.
know, I've heard that. I think there's more violence on the family law floor than on the criminal floor.
The litigation can often be petty as well, can it not?
Sometimes.
Yeah, where you get two parties that are arguing over a pet turtle, for example.
Right. I mean, this was the opposite of petty, but
Yes.
yes, it certainly can be.
All right, and you are, of course,
Or a tennis
Like-
racket.
all of us, an advocate.
Yes.
And in this case, you were an advocate for Doug Benefield,
Yes.
and he paid you.
Come on. The
did he
lawyer
not,
knows
to be
this.
his advocate.
I
He
don't
did.
think he needs to be doing this.
During the hearing that we heard, the ruling for which I think it's a safe bet that the petitioner did not prevail. But would you agree with me that Judge Moreland did recognize that your client, Mr. Benefield, had fired a gun in the home when Ms. Benefield was present?
Yes, she said that in her
Yeah.
ruling.
And she also recognized that he had apparently punched holes in the drywall.
She did say that.
And in fairness, I believe Ms. Murphy, she dismissed the firing the gun in the ceiling of the kitchen as too remote in time.
I believe that's what she said. Yes.
And as to the punching of holes in the wall, I think she said it was not directed at Ms. Benefield, but
I don't know
just
how-
out of frustration.
I don't remember
know
that she
how
said
to
that.
do
She certainly could have.
Okay. Having just recently heard it. So in cases of domestic violence injunctions, would you say what percentage of your clients are females and males that seek domestic violence injunction protections?
Well, I can't tell you if it would be my clients. I think in the cases in which I'm involved, the majority is the female client is seeking an injunction against the male.
Okay.
That's not necessarily indicative that the female is always a victim of domestic violence, because men can also be victims of domestic violence.
Yes. Now, through your 21 years worth of experience in family court, I'm sure you've come to learn that there are some stereotypical factors that seem to be rather common with a lot of abusers. Would you agree?
I do not necessarily agree with that. No, there are different types of abusers.
All right. Would you say that it's reasonably common in those instances where you've represented females seeking domestic violence injunctions against males, that the males are often controlling?
That is sometimes the prevailing foundation for why the domestic violence occurs, but not always.
Is that a yes?
No, it's a no, not really.
It's a no, not really, as opposed to sometimes?
Sometimes.
Okay. I'll take sometimes.
Okay.
All right. Have you had experience in those instances where you've represented females seeking protection from domestic violence, that the males are sometimes jealous and very possessive?
Judge, I'm going to object to this line of questioning as irrelevant.
I think it may be. I don't know. The witness can certainly say yes or no, or agree or disagree.
That is one of the most rare reasons for the domestic violence in the cases that I've had in which I've represented the women. So jealousy is usually not a factor or a major factor.
So you've seen it.
I've seen it, yes, but not often.
That was my question. Have you experienced in representing some of these females seeking protection for domestic violence against males, that they have employed a strategy, which obviously has not been successful, of appeasement over the course of time. And finally, it builds to a sufficient crescendo that they end up as a client of yours.
I have seen that.
Okay. And by appeasement,
All right. I think you got to go, Allie.
Yeah, I gotta go. We're everybody's about to arrive for a party.
Oh,
and
have the party. I'll finish this. Just I think it's just like a little bit. So you go. Thank you for being here, Allie. Make sure you're subscribed to Defense Stars if you're not. Do
yes,
it
and
now.
I think that we'll get some stuff lined up for Monday. Yeah, Jay.
Yeah, we'll look into we could do the same thing we're doing now, but because there's only 2 hearings going on and we have nothing else, so this weekend we'll figure out some stuff to watch to give you.
Bye,
But I
all.
think all right, I'll finish. We'll finish watching this cross and then I'll end
You
it
guys
too.
will call it. All right. Thanks.
Bye.
do we not going along for fear that the reprisal will be greater?
Yes, that is true for both the female victim, if you want to use that word, as well as the male victim.
Mhm.
I hear a lot of whispering. Secrets are no fun. Secret
When
hurt
you
someone.
bring a petition for protection against domestic violence in the family court, are you foreclosed from returning and seeking a second petition?
Do you mean if a petition is denied, can you then file a different petition on the same allegations?
Not on the same allegations.
Okay, then, no, you're not foreclosed. You can file as many domestic violence injunctions as you would like,
Correct.
regardless of how many times they've been denied.
Correct. So in other words, you've had a domestic violence petition denied, and then 2 months later, additional acts occur. You are entitled to go back to family court and file another domestic violence petition.
Of course.
And in fact, have you done that on behalf of clients in the past?
I just want to clarify, I don't file petitions for injunction. So a party would file that on their own, the clerk's office. So my involvement is usually after an injunction has been filed. That is when my involvement begins.
And have you represented people who have gone to court multiple times? Or do you only go one time?
Oh, no, I could go multiple times. I just don't think that I've ever had a situation where I've represented the petitioner who has made multiple injunction petition filings. I've represented several respondents who have been themselves the victim of spurious litigation and abuse of the injunction process by repeatedly filing injunctions.
When Mr. Benefield was living here in Manatee County, he had his own apartment. Is that correct?
He wasn't not living here full time, but yes, he had an apartment at times during this period of time.
You're not aware of any point in time where he resided with Miss Benefield in the home where the shooting took place?
My understanding is that he did not.
I don't believe I have anything further. Give me a moment, Your Honor. That's all, Your Honor. Thank you.
Thank you. Redirect?
No.
Can this witness be released?
Yes.
Mr. Taylor?
Yes.
All right. Maybe release from your subpoena. Thank you very much.
All right, so there we go. We got some background here. I think a few things we learned. Judge Jim Gaffigan. I think we're gonna like Judge Jim Gaffigan. I think it's gonna be spicy between the defense and the state here. It's gonna be a little spicy. But yeah, thanks for being here, everyone. Thank you for watching the other trial. If you did with us, we'll be back next week. Remember, Monday. Bob will be covering the Karen Reed hearing. I will be covering the Donna Adelson hearing, which is at 1:30, set up for 1:15. I'm not sure. I think Karen Reed is 2. So if you want to check those out, check one out, then the other one. And Josh Ritter will be doing a dual stream with me for the Donna Adelson status conference. That's Monday. And then also Karen Reed, which will be on Bob Shell. Then we will start on Tuesday. We will start with this trial, and then we'll talk about maybe if we'll do some further background of the case. Thank you all so much. Thank you, mods. If you are following Publicly Buzz and you're on Kick, they are doing a movie marathon. So check out Kick and Publicly Buzzed. And I think that's it. Thank you all so much. Have a good weekend, and we'll catch you on the next one. Thanks, everybody.